Welcome to this sponsored webinar by OmniBridge Water, hosted by CPA Australia, Demystifying Dispute Financing Litigation as an Asset. My name is John Purcell and I'm Senior Manager ESG at CPA Australia. We have people joining us from all over the country for today's webinar. I would like to take a moment to acknowledge the traditional owners from around Australia and pay my respects to elders, past, present and emerging. I extend this acknowledgement to all Aboriginal and Torres Strait Islander people who may be joining us here today. It is now my pleasure to introduce Christian Smith, Investment Management Team Co-Leader and Investment Manager at OmniBridge Water, and Martine Begg, Director of OmniBridge Way, as well as a CPA member. Today, we'll be taking questions through our Q&A box. Please direct your questions to all panelists. We'll address questions at the conclusion and we'll do our best to address them all. For any troubleshooting queries, please send these as a message to the host using the chat box. It is now my pleasure to introduce this session, ask it to commence and introduce you to Martine and Kristen. Thank you.
Thank you, John, and good morning to all of CPA's members, and a big thank you to everyone for attending today's webinar on demystifying dispute financing litigation as an asset. And before I begin, I think it's quite apt that this is being hosted by CPA Australia, especially given that the concept of dispute financing was pioneered in Australia itself. So thank you, CPA Australia, for hosting this. So before Chris and I get into the nitty-gritty of today's webinar, I think I should start with an apology to all the accountants out there. I say this as an accountant myself. When we talk about litigation, the last thing we think about of treating it as an asset. And you know, from an accounting standard perspective, we probably think of contingent liabilities. But in the world of the funder, we do look at disputes as potential assets. And I guess the whole pandemic situation has given even greater prominence to this view, as corporates have looked at avenues for greater cash generation and liquidity management for their own businesses. Probably move to the next slide, Fiona. Yeah, there's many definitions of litigation funding, dispute financing, call it what you like. We've got a definition there, but in essence, it's where an external party who doesn't have a direct interest in the dispute itself finances the associated legal costs in return for a share of the proceeds, but the funder only receives payments if the claimant is successful in its case. And that's a very important point, I think, at the end, and something we'll come back to a bit later. Next slide, please, Fiona. Yeah, so before I actually get into this, the interaction between finance and legal, I think it's important to mention that from a finance perspective, the management of legal costs does have a significant impact on budgets and P&Ls, because every dollar spent on litigation increases your expenses, reduces your earnings, which can be particularly harmful if you're a publicly traded company where metrics such as earnings per share is an important measure used by the market. Next slide, please, Fiona. Collaboration between finance and legal. Well, this is quite an important area in terms of finance and legal collaborating. It's fairly common, or in a number of corporates, fairly common that finance exerts control over those four areas: their cost management, the budget setting process, establishing recovery goals, and even deciding on which high-value litigation matters to pursue. So by a company consciously deciding to use an external funder for financing its legal claims, it can impact all these four areas, as well as encourage legal departments to adopt a more commercial mindset in their recoveries. Next slide, please, Fiona. The forensic accountant. So how does in the world of public practice, how do they work in dispute financing? Well, typically you have these four areas. I think the big four here in the UAE, they all have these four areas in terms of their forensics team. here at OmniBridge, where we've particularly used the dispute resolution arm for services where we've used experts for loss quantification or damages. Now, next slide, please. Yeah, so dispute financing in times of economic uncertainty. Well, we've been going through unprecedented times over the last 18 months, and the level of economic uncertainty really has gone to another level. As a result, liquidity management has been at the forefront of all corporates, no matter how big or small, and third-party funding has been a source of finance for companies managing their liquidity. So in terms of risk management, well, it's a source of managing financial risk. Non-recourse, I mentioned earlier in the definition that the funder only gets paid if the claimant is successful, and that's exactly what that means here. Our financing is non-recourse, so if the claimant is unsuccessful in its claim, that is a sunk cost to the funder. Adverse cost cover, that's in jurisdictions where you have to pay the other side's costs. And again, if that happens, the claimant's unsuccessful, the funder will pay the other side. And monetizing awards and judgments, and we said in the title, litigation as an asset. Well, from a funder's perspective, that is the key objective in terms of monetizing those awards. And there's just been a huge diverse nature of applications. You can imagine over the last 18 months where claimants have looked at funders as a source of finance. Next slide, please. So what are the sectors? I think we can move to the next one, Fiona. Yeah, I mean, this pretty much covers everything, but these are the sectors which Omni, through its global offices, has pretty much covered cases in all these areas. I'm based here in Dubai, and the areas that are particularly hot for funding applications are typically the supply chain, construction, and infrastructure. So those have been hot sectors here, but I think across our 20 offices, we've pretty much covered all those areas. So yeah, so I'll talk a bit more a bit later, but I'll hand you over to Chris, who does this for real. We'll now talk about dispute financing and how that actually works in the real world. Over to you, Chris.
Thanks, Martine, and thanks to everyone for joining us today. So we've heard a little bit about the definition of third-party finance, but let's have a look at how that works in practice. So specifically, we'll examine how to shift the cost burden of litigation, the upside of risk shifting, excuse my dog, which is whining in the background, and the role of a non-traditional financier like OmniBridge. So I invite you to picture this scenario. Anna and Ahmed's business started as an ambitious idea that arrived over several glasses of wine. They devoted evenings and weekends to develop Beyond the Cork, a wine bottle recycling and refilling business. After 3 years of slogging, they employed a few team members, and then fast forward 5 years and business is booming. They've landed a $20 million contract with a Chinese wine distributor to meet the insatiable thirst of China for a good drop of Australian red. Then the trade crisis with China shattered demand. Despite a multi-year contract, millions of dollars of orders were cancelled in breach of the contract. This style of business crisis is all too common, and thankfully the Annas and Ahmeds of the world have a powerful legal option at hand. So let's explore dispute finance in the context of Beyond the Cork. Anna and Ahmed's business has been left high and dry with millions of dollars owing under the breach contract, which unless addressed is going to cripple their business. They need to enforce their rights under the contract. So what are their options? They could do nothing and destroy the balance sheet and potentially the business. So that's not really an option. They could finance the litigation themselves, but that brings with it substantial legal costs and more financial exposure. Not to mention the time, energy, and psychological demands of wading into a complex legal dispute with an offshore defendant. Alternatively, they could partner with a third-party litigation financier like OmniBridge to fund and help manage their case. So let's get specific. As touched on by Martine, litigation funding is a source of funding that's only paid for if the case is successful, and only out of what is recovered by way of a settlement or judgment sum. It's available to any person or organisation with a robust legal claim. In the case of beyond the corpse dispute, the legal cost would be close to the $1 million mark if it runs to the end of trial. In jurisdictions like Australia, beyond the corpse would also be facing the risk of having to pay the defendant's legal costs if the case is lost. So these are big risks. When a case is funded, the third-party financier takes on the cost and the risk of that company's legal dispute. This lifts the burden from the claimant and partners the company with a specialised financier who's invested quite literally in their success. So let's also be reminded that in most complex disputes, reaching a resolution can often take 2 to 3 years, and it's a very involved process, resulting in reams of documentation and some tricky issues to navigate. So imagine Anna and Ahmed's relief in knowing that that burden can be shared. So they choose to partner with us. Once they make contact with OmniBridge, one of our investment managers is assigned to the case. And all of our investment managers are seasoned litigation specialists with a deep expertise in dispute resolution. So they work in partnership with Beyond the Cork and their team over the entire life cycle of the case, from developing the strategy through to resolving it. And I'll get to that in a bit more depth in a minute. So let's look at dispute finance from another angle. Orion is a mature boutique pharmaceutical firm based in Melbourne. They hold a patent for a novel pain relief drug delivery technology. And the business has recently raised $30 million in capital investments to further expand the market potential of their innovation. So it's a sobering day when their managing director, Tom, realises that an international competitor appears to be breaching the patent and is selling into major markets. The scale of the breach is very substantial, and on Orion's calculations, it suffered about $150 million in losses resulting from infringements right around the globe. So inaction is not an option. Tom determines that dispute finance will allow the company to de-risk the legal action. The company's capital is largely tied up in developing new technologies and scaling manufacturing. Intellectual property brings particular challenges. He needs to enforce his patent rights across 5 different jurisdictions around the globe, and then notoriously complex claims that require a deep understanding of the legal nuances across territories. And patent disputes, as we know, have been on the rise, with close to 4,000 patent cases filed last year in US district courts alone. So Tom decides that Orion should partner with OmniBridge to obtain $15 million in litigation funding to help build a global litigation strategy to pursue the patent infringement claims. OmniBridge's got 18 offices in 10 different countries around the globe, so it pulls together a team of investment managers with experience in patent infringement claims from the 5 jurisdictions where the claims are to be pursued. The investment managers assist Orion to identify leading patent litigators in each jurisdiction to represent Orion, and the investment managers and the legal teams collaborate in determining the optimal sequencing for the litigation to be filed around the world. Australia is chosen as the first jurisdiction in which to file proceedings, so Orion can take advantage of the option to seek pre-litigation discovery, which will help it obtain the documents that it needs to prove the case. The plan is to file follow-on actions in Germany, Canada, and the US, and then Italy, with the hope to win in Australia, and then ideally the parties can attempt to negotiate a global settlement without needing to file in those further jurisdictions. So Tom's a busy executive, and he asks that the investment managers provide the day-to-day instructions to the legal team on Orion's behalf. Litigation is the bread and butter of our investment managers, and as unfathomable as it might be, they actually like dealing with things like settling letters about discovery categories and what the court timetable should be. So this delegation allows Tom to stay focused on Orion's main business activities. He's very happy not to have his inbox clogged up with the minutiae about what questions are going in the letter of instructions to the expert witnesses. Plus, he doesn't speak Italian, but he's very keen to be involved in the big ticket items like settlement discussions. And with $15 million on the line, Tom can feel very confident that OmniBridge staff will be as dedicated to seeing Orion's case succeed as he is. So let's pause for a moment and look at what would happen in the worst case scenario if Orion loses its case. In short, disappointment aside, things look okay for Orion. It doesn't have to pay anything. If Orion's spend is not successful, then OmniBridgeway absorbs the legal costs and disbursements that's outlaid. And in addition to that direct financial outlay on the legal spend over the course of the case, OmniBridgeway will pick up the tab for any adverse cost order that's made in favour of the defendant. If, on the other hand, Orion's case resolves successfully, it receives the bulk of the compensation after deductions for legal costs and funding commission. So here we have a company that's shifted both the legal costs of running the case and all of the risks that attend the case being unsuccessful off Orion's books and onto OmniBridgeway's. Plus, Tom's freed himself up to do what he does best for Orion, while OmniBridgeway takes care of the day-to-day of that complex global legal dispute for him. Tom's way is not the only way, though. The approach to structuring litigation finance arrangements, including who instructs the lawyers, are the sorts of things that we specifically tailor to the wants and needs of each claimant. If the claimant wants to be the one that instructs the lawyers with us taking more of an oversight role, then that is also absolutely fine. So let's get into looking a little bit deeper at OmniBridgeway and how we usually approach things. Go to the next slide. Thanks, Fee. One, yeah, that's one. So a little bit about our background and how we work. So as I touched on, OmniBridgeway operates in 18 countries and has the largest litigation funding team in the world. It's currently got 180 specialists permanently deployed across Asia Pacific, Europe, the Middle East, and North America. And today's disputes sometimes involve parties facing multi-jurisdictional issues, cross-border recoveries, and where these sorts of disputes arise, we can put together a team with local expertise across the various jurisdictions to assist with that litigation. Equally, where we're funding cases in a single jurisdiction, we'll usually have someone on the ground with a deep knowledge of that specific jurisdiction and local laws. And OmniBridgeway has assessed claims or funded parties in hundreds of countries around the world. So next slide, please, Fee. So here we'll just touch on the dispute resolution finance model and a little bit of history. So the modern concept of dispute finance, which Martine mentioned earlier, was pioneered in Australia by OmniBridgeway, which was then known as IMF Bentham. And it was first used to fund liquidators in bringing insolvency-related claims. From there, it has evolved into being used to fund cases where the claimant had a meritorious claim, but typically could not afford to litigate. And it's now in the phase where claimants are considering litigation finance, even in circumstances where they can afford to meet the legal costs themselves, where they see the benefits in de-risking the litigation and shifting the costs from themselves to a third party. Over that evolution, the approach to structuring litigation finance arrangements have become increasingly sophisticated and flexible, enabling arrangements to be specifically tailored to the claimant's needs. So here we'll just outline how the relationships work between the clients, the lawyer, and the funders. At its most basic, the relationship is a tripartite one, and how that works in a day-to-day sense is really tailored to what the funded claimant's wants and needs are. So at the outset, after being approached for funding, the funder conducts detailed due diligence, and it works with the claimant and the law firm in assessing the strengths and the weaknesses of the claim and the proposed litigation strategy. And that due diligence process can be a very valuable second pair of eyes on the claim, and that proves useful in most cases to the claimant, irrespective of whether the matter winds up being funded or not. We think if a claim is suitable for funding, we'll work with the claimant to sort of shape the funding arrangements to fit their needs. And sometimes that's even involved providing working capital in addition to financing the legal expenses of the dispute. If the investment manager forms the view that the case is one that the business should invest in, they'll present that opportunity to OmniBridgeway's investment committee, which is the body that ultimately decides whether or not to offer funding. And where the claim's approved by the investment committee and accepted by the client, then a litigation funding agreement is entered into by the funder and the claimant. And that kicks off the process of the funder paying the claimant's legal bills on the way through the litigation. So all three parties work together to a greater or lesser degree in project management of the case. What we've seen so far is a bit of a divergence in terms of the appetite from corporate clients in terms of how to structure that day-to-day case management. In some in-house teams, they prefer to take the running on providing instructions to the lawyers, with the funder taking a backseat and just getting involved at key stages of the case, like as part of settlement discussions, for example. Other claimants, particularly those with less litigation experience or with a smaller in-house team or teams that have less of a litigation focus, they want to delegate that day-to-day matter management function to the investment manager that's assigned to the claim. Our investment management team, as I touched on, are all very experienced litigators, so they've got that experience available to draw on if a claimant desires. So working with a funder can avoid there being a drain on the in-house legal team's human resources if they wish to structure things in that way. In terms of what happens when settlement prospects arise or are to be discussed, the claimant, the lawyers and the funder all work together. So to sum up, we pay the lawyers' bills, the claimant retains the lawyers of their choice, and we work with the lawyers and the claimant in relation to the case and costs management to a greater or lesser degree depending on preferences. And I think the main point is that the option for claimants to draw on our experience in independent oversight of case strategy and the legal expenses is there, and our expertise can operate to relieve pressure from a claimant's in-house resources if they wish. And that happens while the claimant retains full control over decisions. Go to the next slide, please, Fee. So here I'll just briefly touch on the sorts of disputes that are typically suitable for financing, which I think can broadly be summarised as any damages-based claim of significant value with strong prospects of success. So they can be commercial disputes, arbitrations, class or group actions, insolvency actions, enforcement of judgments or awards, or debt recovery actions. The key thing we look for are claims where the requested funding amount represents about 10% of the overall claim value, because this metric usually provides for the claimant to receive back the lion's share of the recoveries after costs. And I'll also highlight that we sometimes provide initial funding to a claimant, referred to on this slide as seed funding, to help them develop the case. And sometimes we also provide a working capital advance to the claimant, which the business can use as they see fit pending resolution of the claim. And this aspect might be particularly appealing in today's economic climate, or where a company is cash poor as a result of the impact of the claim that they're wanting to pursue. So I'll now hand back to Martine.
Thanks, Chris. So we've called this the 3 steps to finance, and this is how we typically do it at Omni. I suspect it won't be too dissimilar if you look at any other funders, but it typically starts at step 1 being the preliminary discussions between funder and the client. Here we put in place a confidentiality agreement, and the funder carries out an initial assessment just to understand the merits of the case. Then in step 2, typically a term sheet is issued. We feel that the case is worth progressing. We give indicative funding terms based on the initial assessment that was carried out. And here the focus is on the merits of the case. We're defining the quantum, the strategy, the legal strategy. Does the counterparty have the ability to pay, the likelihood of success, and an estimate of the budgeted costs? And if all of that goes well, we get to stage 3, which is the funding agreement itself. That lies at the heart of the whole relationship between the funder and the client, and it's pretty much a detailed extension of the term sheet with some additional terms. Next slide, Fiona, please. Yes, so these are the typical attributes that one would look for when selecting a funder. Capital, does the funder have the firepower to fund the litigation? Transparency, we're Omni, we're listed on the Sydney Securities Exchange. Track record, obviously that's quite important in terms of the funder having a track record of successful recoveries. Has the funder generated returns? The talent of the team in place, do they have the expertise to carry out some complex complex recoveries. Asset tracing, that's a major part of what we do here at Omni, especially on the enforcement side. We have a dedicated asset tracing arm. And relationships, I mean, that's quite important as well. Do you have the network of people to draw upon when you need to? And most importantly, it's there as the last point, but alignment of interest. You know, the funder always needs to be aligned with the claimant. And as Chris said, you know, the claimant typically will always get the lion's share. And then we've got some stats on the side of how we've done it at Omni into last year. Yeah, next slide, please. I think it's you, Chris. Insurance.
Yeah. I thought it might be valuable for CPA members to consider business interruption insurance claims, and in particular whether their clients held business interruption insurance, particularly during 2020. So many businesses throughout Australia hold insurance that likely provides cover for losses caused by business interruptions, including interruptions arising from human infectious or contagious diseases. Some of these policies likely respond to losses relating to the COVID-19 pandemic. Some policyholders have been told either through the media or via their brokers that their insurance policy does not respond to COVID-19 related losses. However, there's a question mark over whether that conclusion that's been communicated is correct. So back in October of 2020, ASIC issued a letter to the directors of general insurers, Lloyd's cover holders and general insurance brokers in relation to their handling of BII claims resulting from the COVID-19 pandemic. And in this letter, they state that they've been monitoring these issues for some time and they've reviewed close to 400 policies issued by general insurers to Australian small businesses. And whilst a considerable number of those policy wordings contain exclusions for losses arising from pandemics, they identified a range of policy wordings that may respond to COVID-19 related loss. So the takeaway from that is that it might very well be worthwhile for clients of CPA members to review their policies of insurance to determine firstly whether they hold business interruption insurance, and if so, seek legal advice about whether the policy likely covers them, and make a claim. OmniBridge is presently funding 2 class actions against insurers for losses relating to the COVID-19 pandemic, and the cohort of class members are businesses sort of big and small. The lawyers acting in both of those matters are continuing to investigate claims against other insurers as well. So we've got sort of 2 cabs off the rank, but there may well be more. And I note that Gordon Legal, who are the lawyers running the class actions, have reviewed hundreds of policies to date, and they're currently offering to review policies free of charge with no obligation for policyholders. So that avenue for seeking legal advice at low cost is, no cost, I should say, is available. So further information about the class actions that OmniBridge's funding and how to join can be found on OmniBridge's website. And I've just put the link in the slide there in case anyone wants to get there directly. And we've also had inquiries from a range of individual businesses with bespoke business interruption insurance policy wording who have substantial amounts of cover, and we'd welcome a discussion if that is of interest to anyone on today's call. So I think might hand back to John, and we can do some Q&A.
Yep, certainly at this stage, would like to invite questions from our audience. But I'll kick off myself with a couple of questions for you, both Martine and Kristen. 2020 was a fairly active year here in Australia, and before that through the Australian Law Reform Commission, looking in particular at the litigation funding of shareholder class actions and measures to start to regulate that market. With questions about whether there was actually need for regulation in that particular space. Just wondering if we could get your views on where matters settled in relation to the various recommendations come particularly from the Parliamentary Committee.
Yeah, the key sort of regulatory change in the Australian litigation funding market was in relation to removing an exemption for litigation funders to hold an Australian financial services license. So that was, and so OmniBridge is now an AFSL license holder. And in order to run class actions, they now need to be structured as managed investment schemes, which is, it's fair to say, it's a slightly awkward fit with the regulations, but we are sort of managing that process, and we've stood up, I think, 6 or 7 different managed investment schemes relating to class actions to date. So we're navigating it, but it's fair to say that there's lots of questions that I think are still in the mix, and there's been a recent consultation process that's been kicked off by ASIC to try and sort of iron out some of the kinks in the process, because there's a lot of uncertainty about certain aspects, and I'm sure many class members are a bit confused when they try to sign up to a class action and are met with a product disclosure statement and managed investment scheme rather than just signing a funding agreement and retaining lawyers as they used to do.
Yeah, it was a little bit of retrofitting of securities regulation into into a novel area, but also, and again, this stems from some of the initiatives around response to the economic impact of COVID-19, and that is in relation to the continuous disclosure regime under the Corporations Act and the ASX listing rules. Do you see the changes there having an impact on shareholder class actions and how directors might be pursued in relation to their continuous disclosure obligations?
Yeah, I mean, it's obviously going to make it more difficult for shareholders to institute those claims, because the changes to the continuous disclosure laws introduce a knowledge element, whereas before it was more of a strict liability test that was applied. So if a company failed, irrespective of what they thought about circumstances, to disclose what they needed to disclose to the market, then a cause of action arises. But now there's this knowledge and fault element that's been introduced. So I think it will raise the bar.
Yep.
But that said, I think that the trend in terms of shareholder litigation, even prior to the introduction of those laws, was on the decline and has been for a number of years.
Okay.
Listening to you both talking about class actions, I'm sitting here, I'm based in the UAE office in Dubai, and we're not allowed to have class actions here. It's against the law. It's a major part of what we do. I know in our other offices, but here in this region, albeit we are getting a little bit more regulation here, to the extent that there's 2 big free zones: the DIFC, which is the Dubai sort of financial free zone, and the ADGM up in Abu Dhabi, the capital here, and they've both issued sort of rules and disclosure rules for funders. But yeah, I mean, it's interesting. You're talking about the impact of COVID-19, and you know, that in itself is just seen, you know, for an asset class which is not that developed. I think in the last 18 months we've seen a significant amount of an uptick of applications from this region.
Across these discussions, probably, with respect, one of the terms which I'd like to draw your thoughts out on, and that is how these mechanisms actually underpin access to justice.
class action mechanisms
Yeah.
or litigation funding more broadly, John?
Class actions, or no, litigation funding rather.
Yeah, I mean, it's obviously, it's the reason that I sort of have chosen to work in this sphere, because litigation funding is absolutely the key to allowing access to justice for very many people. Litigation, as we know, is just exorbitantly expensive as an exercise, and many companies and individuals, I think, look at the prospect of being able to self-fund and just don't have the means or wherewithal to do it. So I think litigation funding on its own and in the class action context provide extremely important sort of public service in that way to sort of even the playing field between you know, bigger players, or
Yes.
even access it itself.
Yeah, and you know, dare I say it, the whole history of James Hardy Industries indicates, issues around differential power in terms of being able to gain access, particularly in a timely manner, particularly when it's personal injury type claim.
Yeah, we don't fund much in the personal injury space, but mainly because many plaintiff law firms have been willing to run cases on a no-win, no-fee basis in that sphere. But we do, so we tend to focus on the commercial side of things, but in both realms, there's absolutely a need for people to be able to go through the court system, and the costs prohibit that in a great many instances.
Yeah. You know, one area which I have had a bit of an interest in over the years, and I think you touched upon it on a couple of occasions, both of you, and that is in relation to cross-border insolvency. Do you see much of a private market emerging around actions in relation to recovering bribery of foreign officials, money laundering, and that unfortunate situation where politicians raid sovereign wealth?
I haven't seen any cases myself in that realm, John.
Yeah.
We do have a class action on foot, which is a securities class action that arises out of the Commonwealth Bank's alleged breach of the Anti-Money Laundering and Counter-Terrorism Financing Act and AUSTRAC's action. But in terms of individual stuff, no, I haven't seen anything, but that might be something that our overseas colleagues see more of. Martine, have you seen anything in that realm?
Yeah, well, so the office here in Dubai is a collaboration with IFC, an arm of the World Bank, and when anyone mentions politicians or PEPs, as we call them, you run a mile. I mean, we're just not allowed to touch them here, just from a reputation perspective. But I know historically, you mentioned about, you know, formerly IMF Bentham and OmniBridge and Legacy Omni. I know Legacy Omni, that is the Dutch arm of Omni, they've done quite a bit against sovereigns across a range of countries, and that's something which I know they're still fairly active on, but not here in this region in the Middle East. You know, there's not been much on that front. Albeit in the Indian subcontinent, you know, there have been, you know, one of the areas I work in is a non-performing loan market, and you have banks across the MENA region, and we have had situations where you've had obligors in India, Pakistan, the Indian subcontinent, who have assets outside of their home countries, typically Europe, the US, Canada. So, you know, the cross-border side is you're always looking to find friendlier jurisdictions where you can export judgments to jurisdictions with a view of recovering or recognizing those judgments abroad. So that's something which I have seen.
Mm. And I think that issue around choice of jurisdiction is certainly something which was addressed when the international rules around cross-border insolvencies were harmonised to a degree, and giving rise to sort of cross-border judicial collaboration.
Yeah.
At a cross-border level, do you encounter issues around who has priority to bring claims at all against particular defendants?
We frequently collaborate with our colleagues overseas where there's multi-jurisdictional disputes. Comes up a lot in the IT space, comes up in ordinary sort of commercial disputes where you might have an Australian judgment, but you need to enforce it overseas. It happens quite frequently, and
Okay.
And it's very helpful to be able to sort of talk to international colleagues and work out strategically which jurisdiction is the best one to commence in. It's obviously very case by case specific, but you to look at the local laws in each jurisdiction and can formulate a strategy based on what looks to be the most optimal kind of way to roll it out.
Okay. Looking a little bit more broadly, in the Asia Pacific, do you see much development of this type of market in New Zealand?
Yep, we have an investment manager that's based in New Zealand, and she looks after that jurisdiction. She's a New Zealander. She worked with us in Melbourne for a little while and is now permanently stationed there. So yeah, it's an expanding market. We've operated in New Zealand for a number of years, but it's a recent thing that we've had a person on the ground there.
Okay.
I think we've got an office. I think our slide said 18 offices, Chris, but we're up to 20. We've got New Zealand and Spain in Europe. So yeah, we've got people on the ground in both those places now.
Yeah. Okay. Now we're going to go out even on a bit of a broader tangent here, and enter into possibly one area of public law. You may be familiar with a decision here. I think it was from Justice Romberg in the federal court, a mining case in which he made a decision that the Commonwealth owed a duty of care in relation to climate change matters, and that duty of care was owed to the younger generation of Australians. Do you see that opening up the door for greater climate-related litigation-funded activity?
Yeah, I think that it's obviously a developing area of jurisprudence, but I think we're increasingly going to see a trend in climate and environmental-based litigation. We've already had several substantial cases happen in Australia in relation to contamination, and OmniBridge was funded previously some 3 class actions in relation to PFAS contamination for the claimants were people whose property values had diminished as a result of PFAS contamination, and they were settled times a flat circle in lockdown, but a year or so, a little bit longer ago. And I think with increased sort of public interest litigation setting some of these precedents and what have you, this is an area that's going to expand in the coming years, is my tip.
Okay, an interesting area to be working in over the next decade or so, I would say.
Yeah, I think
particularly with the onset of physical climate change risk impacting quite wide range of activities in Australia.
Yeah, and around disclosure obligations in relation to cleanup costs, all sorts of there's all sorts of issues in play, I think, in that space that will develop.
Okay. Look, I suspect we're pretty well moving towards the end of what has been a very interesting presentation and discussion. Just go on one final thing, jumping back to the world of finance. It's probably a bit of a naive question, but is there any sort of secondary market or opportunity for securitization of any of these commercial side of these activities, or is that a remote possibility?
Well, OmniBridge is publicly listed, so in that sense, you can invest in our business activities. If that's what you're getting at, John. Yeah.
Yes. Yep.
Yep. Yes, and a lot of our capital comes from external investors through a fund structure.
Okay. All right. Well, look, I would invite you if you've got any sort of final remarks, takeaways from this discussion before I hand back to host.
No, just to say thank you to everyone who's attended, and if you've got any questions or would like to reach out to us, feel free. We'll arrange to circulate these slides, and our contact details are available on OmniBridge's website.
Okay, it's my pleasure now to hand back to Lauren. Thank you.
Thanks, John, and thanks, Martine and Kristen, and thank you to everyone for your participation. In the next 3 working days, you'll receive an evaluation survey accompanied by the recording of this webinar. We really appreciate your feedback, as it is extremely valuable to CPA Australia to help us deliver better events for you. Thanks again, and we look forward to welcoming you to another CPA Australia webinar soon.
Thanks very much.
Thanks, Lauren. Thanks, John. Thanks very much.
Bye.
Good day. Bye now.
Thank you, everyone.